Good afternoon. I wanted to start this recording. This is being recorded. And we will get started. Good afternoon. And welcome to the 2023 Harter Secrest and Emery overview of the updates for New York State labor law. I'm Cathy Piciulo, the President and CEO of the Kenmore Town of Tonawanda Chamber of Commerce. And we have hosted this event for the last few years and are pleased that so many of you have joined us today. I wanted to let you know that if we do have any technical issues, please know that we will be recording the presentation and we'll email you a PDF of the presentation along with a link to the video recording. The email will include the contact information for the attorneys and you can contact them with any questions. So thank you for joining our very popular speaker series presentation. Please welcome Harter Secrest and Emery attorneys Anna McCarthy and Chloe Macdonald, who are here to provide us with valuable insights on the updates to the New York State labor law. Anna is a senior associate in the Labor and Employment Practice Group, where she assists clients with complex employment law issues. And Chloe is also an experienced associate in the same practice group and has a deep understanding of the legal implications of labor law changes. We are thrilled to have them both here with us today to share their knowledge on this critical topic. So let's give a warm virtual welcome to Anna and Chloe and get started with our presentation.
Thank you so much, Cathy. It's really nice to be here again. Good morning or good afternoon, everyone. Thank you for joining us very much for the 2023 Labor and Employment Law Update for the Kenton Chamber of Commerce. As always, we're very happy to be here. And thank you so much to the Chamber of Commerce for inviting us. So as Cathy mentioned, my name is Anna McCarthy. I'm a senior associate with Harter Secrest and Emery, and I'm joined by my colleague, Chloe Macdonald. We're from HSE's Labor and Employment Practice Group, as Cathy mentioned, and we're going to discuss some of the highlights in our area of the law that have occurred in the first part of this year and some at the very tail end of last year.
Hello, everyone. I echo what Anna had to say. Very excited to be here to discuss these important updates with you. As you'll see by our agenda, we're going to cover quite a few issues. So it's going to be a rapid fire of information. We're going to focus on changes to the New York State law. We'll also cover some federal updates. Like Anna said, some of these changes came in the very beginning of the year, tail end of 2022, but some of them are super recent. So Anna, in just a moment, is going to talk about updates to the state's sexual harassment model policy. And those updates were just released last week. So this is a very timely presentation. And with that, I'll turn it over to Anna.
Thanks, Chloe. So yes, as she mentioned, the first thing we're going to be talking about is something that happened last week. So this is an update to New York State's sexual harassment resources. This change was, or this upcoming change had been announced earlier this year, and the final resources were published early last week. So very recent change. So as I'm sure all of you are already familiar, the New York State labor law was amended a few years ago, requiring all employers to adopt anti-sexual harassment policies and training programs that meet or exceed certain standards. As part of that requirement, employers could create their own anti-sexual harassment policy and training materials, or use an outside trainer, or they could adopt the state's model policy and use the state's training materials, all of which are available through the New York State Department of Labor website. As part of that statute that was passed in added in 2018 to the law, there was a note that said that the state would review and revise as needed these materials every 4 years. So we came up on 4 years last year. They had a committee to discuss potential changes, and then the changes just went into effect this year. Notably, the minimum standards that you have to meet for your policy and your training materials, those have not changed. but the materials that the state has provided to assist employers have changed. And we'll explain what that means. Essentially, you should take a look at these revised materials and consider whether you need to make changes to your own materials, but that may not be necessary depending on what you've done. We'll get to that in a second. I just want to give you a brief overview of what the updates actually included. So if you look at the revised model policy, some of the changes can be characterized as simply restating or elaborating on the original content. So there's not been a change to the law this year, but just a change to the content that's included in the revised model policy and some elaboration on some old concepts. There are some new substantive changes, though, for the revised model policy. And those changes include, first, multiple reminders that both harassment and discrimination are prohibited. Again, not a change to the law, but just a reminder. Not just on the basis of sex and gender, even though this is a model policy for sexual harassment specifically, but there's a reminder in the policy that discrimination and harassment are prohibited on the basis of any protected characteristic under New York state law. So race, religion, familial status, military status, genetic information. There's a whole host of protected identities under New York state law. And the methods for reporting and investigating discrimination and harassment based on any protected characteristic are the same in all cases. So, for example, in addition to having a policy on sexual harassment, you should also have a complaint form that employees can use to report sexual harassment. But you should note that employees can use that form to report any type of alleged discrimination or harassment in the workplace, and your response should be the same across the board: a timely and fair investigation into any complaint received, whether it's on sexual harassment or anything else. So that was one addition to the revised model policy. Another addition was more expansive definitions and explanations for sex and gender terminology. Terms like cisgender, transgender, non-binary, those were all added in as terms and definitions into the revised policy. And a reminder that sex and gender as a protected identity includes sexual orientation, gender identity, gender expression, and sexual orientation. I'm sorry, I said sexual orientation twice, but a reminder that sex and gender is not just biological sex, but includes many other things. They also added sex stereotyping as an example of potential gender-based harassment. So we're seeing a lot of additions of examples of sexual harassment, things that were previously considered sexual harassment under the law, but may not have been actually included in the model policy. Other changes include an emphasis on the many internal and external methods and avenues for making complaints, which include not just emailed or verbal complaints to the employer by the employee, but also a new external form of complaint method, which is calling the Division of Human Rights, the New York State Division of Human Rights Sexual Harassment Hotline number. This was recently created, and it's another method for individuals in New York State to make complaints to the DHR. And so that hotline is 1-800-HARASS-3, and individuals can call that to make a complaint if they don't want to do so internally with their employer. There's also more detail regarding the responsibilities of managers and supervisors. Again, no new requirements, and just a reminder that the old requirements still exist. So, for example, managers and supervisors cannot keep any or can't turn a blind eye to sexual harassment in the workplace. If they suspect sexual harassment is occurring, or they actually receive a complaint of sexual harassment, they have to act on that by reporting it to human resources, by intervening potentially, or both. So they have a duty to report on any suspected or reported sexual harassment. The state policy, the revised state policy, just notes that in addition to that duty, managers and supervisors should be aware of and accommodate the needs of individuals who have experienced harassment to ensure that the workplace is safe and supportive. So there is a potential fear sometimes that employees hold that if they report something, they might be retaliated against. They might receive perhaps poor working conditions, They might receive some blowback for a complaint that they've raised. So the revised model policy simply notes that while managers and supervisors still have a duty to forward on any complaints of sexual harassment to management and to human resources, they still have to be aware of the fact that there may be concerns from individuals about potential retaliation, which would be prohibited under the law. Couple of other additions. One is the addition of information on bystander intervention, so methods that people can use to intervene to assist potential victims of sexual harassment. So there's a discussion of that in the policy. And I mentioned before some new examples of sexual harassment highlighted in the policy. Things like the intentional misuse of an individual's preferred pronouns, and some prohibited forms of retaliation, like publicly releasing personnel files. That's a prohibited form of retaliation. Refusing to provide a reference to an employee. That's another form of prohibited retaliation according to this revised model policy. And then finally, the last change that I think is important for you to note is that they added in some references to remote work. So back when this model policy was first introduced by the state, remote work was not exactly ubiquitous like it is now. This was pre-pandemic. Not as many people were working remotely. Now, many people work remotely. So there's an acknowledgement in the revised model policy that harassment can occur when individuals work remotely, and that harassing remarks or images shared over virtual platforms like Zoom are not acceptable, as well as sexual harassment that occurs in a physical workspace. So what should employers do? If you used the model policy that came out in 2018, you should wholesale replace that with the revised model policy. If you did not use the model policy back in 2018 because you created your own sexual harassment policy, then you might want to just consider comparing your policy with the revised policy and update as needed. So there is some new information in that revised model policy that might not be in your own sexual harassment policy. Consider including that information. And then I think it's a good idea to ensure that your training materials continue to meet the state's minimum standards. The state has now refreshed and new materials for you to use for your annual sexual harassment training. You could consider using an outside trainer. You could do your own internal training, but those training materials I think are really helpful if you need any ideas about what to do for your annual sexual harassment training. So with that, I'm going to move on to, or let Chloe move on to our next update.
All right, so this update I think is a little less interesting than the update on the model harassment policy. I find that to be very interesting, but here is we do this reminder every year. We've done this presentation for several years. So here is the reminder that yes, there were minimum wage increases at the end of 2022 rolling into 2023. Make sure you're working with your payroll providers to update those. And we're going to talk a little bit about pay transparency and a new law with respect to that in a few slides. And so when you have things like a minimum wage increase, it's important for employers to be thoughtful about how that increased starting wage will impact the pay for our longer tenured employees, especially because some of that pay information is going to be a little bit more public now. So in addition to the wage increases, we also have a salary increase for executive and administrative exempt employees. Again, the numbers are on the slide. I won't read them to you, but just make sure again that if you have employees that are classified as exempt under the administrative or executive exemption, they're going to need to have a salary bump. If they were previously at that $990, they're going to need to go up to that $1064.25. New York State does not have a salary requirement for professional exempt employees. So to the extent you have exempt employees under the professional exemption, you revert back to the federal minimum, which is $684 per week.
So Chloe just mentioned the new New York State pay transparency law. This is a big one, and many of you may have already heard about this. So in December of last year, Governor Hochul signed into law New York State's compensation transparency law, which makes New York State among several other states that have some sort of pay transparency law on the books. within our state, this is already law in New York City, Westchester County, and Ithaca County. And now the state has this broad statewide law as well. It doesn't yet go into effect. It's effective September 17th, 2023. So you have some time to get your ducks in a row in terms of compliance with the law, which is helpful because I think the larger you are, the more cumbersome this might be. So you've got a few months to make sure you have everything lined up for compliance. The law was amended in early March to clarify a few things, and I'll point that out in a moment. So what does the law actually require? The law requires employers with 4 or more employees and recruiting agencies to include in posts for jobs, promotions, or transfers the range or the compensation or range of compensation for that job, promotion, or transfer. And if one exists, the job description for that job, promotion, or transfer. The range of compensation is defined as the minimum and maximum annual salary or hourly range of compensation for that job that the employer believes in good faith to be accurate at the time of posting. And this covers any job that is physically performed, at least in part, in New York State, plus jobs that are physically performed outside of New York State, but that report to a supervisor or an office or a work site in New York State. So as you may gather from that, this does cover some remote work jobs if they report to, again, a supervisor, an office, or a work site in New York State. So it's pretty wide ranging and far reaching. Just a quick note for commission only jobs, they have to state that they're paid on commission in the posting. Now this doesn't supersede local pay transparency laws, and there is one instance in which New York City is a little more expansive than New York State, and I'll point that out in a moment. But so the law in New York City I mentioned was amended in early March already, even before it's become effective. And this clarifies the coverage for remote working positions. And this is where the law is different slightly from New York City. So if you've got employees in New York City, maybe across the state, just note this. So the New York State law clarifies that the law covers, again, jobs physically performed, at least in part in New York State, plus jobs physically performed outside, but that report to a supervisor, officer, work site in New York State. The New York City law is slightly more expansive and includes all remote work positions as long as the job can be performed in whole or in part in New York City. So that's basically any remote work position almost, I think, or I think the state could take, or the city could take the position that that's all remote work positions. So there's just a slightly broader scope in New York City. The amendment also clarified that the law covers both internal and external postings. So if you think about a posting on a bulletin board in your worksite for a promotion opportunity, this would fall under that requirement. And the law actually removed, the amendment, removed a record keeping requirement that was in the original law. But the state still has a requirement to keep pay records for at least 6 years. So we would recommend documenting your efforts to comply with this law. And that would also come in handy if you're ever audited or your practices are ever challenged by the state. Now, a note that there are some anti-retaliation provisions and civil penalties. So the law in this case does not expressly create private right of action, but individuals can file complaints with the Department of Labor for suspected violations. And there are civil penalties of up to $1,000 for the first violation, $2,000 for the second violation, $3,000 for the third. So there are potential penalties here. I mentioned there's a similar New York City law. It went into effect last November. Very similar. We've been using that to interpret the New York State law for now, pending guidance from the state, just to sort of get an idea of where the state may be going with their law. So the guidance issued in New York City has some interesting tidbits. So for example, the salary range can't be open-ended. You can't say something like a maximum of $50,000 per year or $15 an hour and up. It has to be a specific range, or if you're going to if you've settled on an exact amount, like $20 per hour or $60,000 per year, then you put that. But it can't be open-ended, at least under the New York City guidance. This requirement to post salary in New York City, at least per the guidance, doesn't include for other forms of compensation. So you don't have to list that you give PTO or severance, or that there's overtime opportunities, bonuses. And there's nothing in the state law that covers that either. So pending other guidance from the state, the posting does not need to include those other forms of compensation or benefits. Notably, just for your reference, in case you have New York City employees, the civil penalties in New York City are much steeper, but there's an opportunity to cure a violation. So they're not trying to trip anybody up, it seems. They just want to make sure that everyone's complying with this new law when they should. And I'm going to pass it on to Chloe to talk about a few of the issues that employers may want to anticipate.
Sure. So for a New York State employer, what should you be thinking about as the effective date of this law quickly approaches? Well, first of all, let's take a look at our jobs and what we think we might be posting for in the future and start thinking about determining the appropriate range. It may be helpful if you want to post for a manager position, but maybe there's different levels of managers. Maybe you're posting for a software developer and there's an entry level position and there's a senior position. It may be very helpful to break up those positions and post for an entry level, a mid level, and a senior level to allow you to narrow that range, right? If you would pay an entry level developer $50,000 and you would pay a senior level $100,000, and you're going to post for it and would have to post a range of $50,000 to $100,000. That's a very wide range that candidates are going to see, and that might really change the candidate's perception as they go to apply for a job, what they might expect to make. We should also think about handling discrepancies between current employee pay and job postings. We'll talk about how it would be helpful to do a pay equity analysis and just to generally analyze employee pay. We want to be mindful that our current employees are now going to see what the rate might be for somebody coming in to work in a same or similar position to what they're currently doing. And if those employees are being paid less than what you would offer a current candidate, maybe due to the job market, that's something to be mindful of, and you might have to take some action towards those current employees to appease them. So you'll want to deal with those potential pay disparities on the front end, perhaps before you even have to post a position with salary. You'll want to be thoughtful about remote work positions. Like Anna just said, this law does apply to remote work if the person is reporting in New York. And so, posting for a remote job isn't going to get you out of complying with this pay transparency law. Tying salary and wage expectations to a candidate's experience level can be very helpful. Like the example I just shared, maybe breaking up a job posting or job descriptions into entry, mid, and senior level can help take that wide range between what you might give an entry level employee and an experience level employee and make it more manageable and more presentable to candidates that you're bringing in for potential jobs. Now, nothing in this law says that you have to post or advertise. And so to the extent maybe you're posting for a very high level executive position, a position where you may not want pay to be posted or a job description to be posted, consider conducting small scope word of mouth searches versus making an advertisement or a posting on Indeed, right? That will allow you to keep some of that information close to the vest. You don't have to post or advertise. You also are able to negotiate. And so just because you posted a range does not mean that you have to stay within that range if a candidate is able to come to the table, offer a lot, and negotiate you out of that range. But the range that you post should be what you believe in good faith you're going to pay for the job at the time. So don't use that as a workaround to maybe post a lower range than you actually expect to pay. But be mindful that you can still negotiate with candidates. Be ready to field those questions from current employees and job candidates on salary. It's putting this pay rate, salary, hourly wage, it's really putting it at the forefront of candidates' mind. It's going to be, I think, sometimes helpful for employers to see what the job market is and be able to look at competitors and determine how much they're paying their new hires, right? But it also may have the effect of, driving up wages and certainly making perhaps employees more able to go between jobs, because they're going to know when they apply for a job what the salary range might be. So this is going to have a really big impact for employers in New York State, and important to start preparing for it now. So how should you prepare? Well, I mentioned conducting a pay equity analysis, which is just a statistical way of analyzing pay disparities in your workplace. I looked this up before putting this training together, and there are websites that have templates in Excel that can help you do this analysis. If you don't want to hire some sort of a firm to do it, but conducting that analysis can be helpful in making sure that your current pay rates are where they need to be and that there aren't going to be any issues with current employees. You should review and update current job descriptions. Sometimes job descriptions are those things that get written and then they sit in your desk for 5, 10 years. They're dusty, they're outdated. If those are going to be posted, let's make sure they accurately reflect what people are doing. Because if they exist, you need to post them. To show your compliance with this law, document your pay analysis and what you considered in setting pay for this position and your reasoning for decision making. It's always good to document your process. It's your first line of defense. And make sure that your employees who are responsible for the hiring process, right, who are responsible for posting jobs to Indeed, who are responsible for negotiating pay decisions, are aware of this new pay transparency law and the obligations that go along with it. We are still waiting on regulations from the New York State Department of Labor, so it may be that those regulations provide us even more information. We might get a nice guidance document like there currently is in New York City that could be more helpful to employers as we go forward. So keep a lookout for that as well.
Yeah, we may see some differing or more elaboration on the concepts and the interpretations that we've thus far been able to draw out of the statute and the way that New York City is doing things. I mean, for example, there's all kinds of potential questions that arise out of this. Sort of a funny one is what do you do with job flyers, job fair flyers? And thus far, what we've been able to gather from the way the statute's written and the way that New York City has interpreted their own law is job fair flyers do fall under potentially this law in terms of posting. So the question becomes, do you need to list the salary ranges for 8 different positions you may say are available at this job fair to potentially apply to? And does that mean you need to include job descriptions for all 8 of those positions? I mean, this is something that requires more in-depth conversations, and there are creative ways to approach this, but it does definitely have, as Chloe mentioned, some far-reaching implications, and we're hopeful that we will see more guidance from the state. Although, as often happens, it may come on the eve of the deadline to comply. So don't wait for regulations to start thinking about how you are going to comply.
Yep. Anna and I, as labor and employment employers, love the last minute guidance that the state likes to put out. It's always so helpful. All right, I'm also going to talk a little bit about electronic posting requirements. This is a law that took effect at the tail end of 2022, back in December. And under this law, employers have to provide employee rights posters electronically to their employees. And this can be done through a website. It can be done through email. I know that my employer has an intranet site where it can post policies. And this includes all documents that are required to be physically posted in the worksite pursuant to federal or state law. So I'm sure many places have a bulletin board where there's a bunch of posters tacked up. It's taking all of those posters and putting them in electronic form. Employers must also provide employees with notice that these posters are available electronically. And that makes sense, right? It wouldn't be very meaningful to put these things up in electronic form and then not tell employees that they were posted there. That's not very helpful to anyone. So with this new electronic posting requirement law, it's a really good time to make sure that all of your postings are up to date and that you're covering everything you need to cover with your posters. Luckily, New York State and the federal government both have helpful websites that list all the posting requirements, and they have links to the PDFs of all the postings. Very easy tools to check yourself and make sure that you are complying with all of your posting requirements, because if you don't, there is, potential for fines. Maybe your minimum wage poster still says $7.25. It's been up there for a very long time, right? Let's make sure that we're updating those posters, such as minimum wage, that need to be updated on a yearly basis. Things to think about when it comes to this requirement: where are you going to post? Again, it may be an easy question. You have a website, you have an intranet where your employees will have access to this. Maybe you already put policies and handbooks and stuff in that type of format. But maybe you don't have an intranet. Do your employees have email addresses through the company? In that case, you could send those policies via email. Perhaps you have some sort of a payroll portal that may even be able to post policies to it. That could be an option as well. As I mentioned, you need to notify employees that things are posted electronically. So getting the email with the policies could be noticed, hey, these are available electronically. But if you're posting them on a website or an intranet, don't just post them without telling employees they're there, right? You would want to also send out a mass communication to employees, letting them know that these posters are now available electronically. We recommend posting links that tie to the PDF version of the poster from the government website. Those links on the slide previous have all of the PDFs available, and so you could post links using those websites. Very easy to do. And then again, make sure to update links when new posters become available. There is a new minimum wage poster because we just had an increase in the state minimum wage at the end of the year. So things like that, make sure that we're doing probably a yearly check to make sure that all of our posters are current and up to date.
All right, so our next topic in our buffet of labor and employment updates is a note on protection for lawful absences. So this was an amendment to the labor law that became effective in February of this year. And you may have seen some guidance out there about no-fault attendance policies that relates to this change in the law. So the change says that protected activity includes taking legally protected absences under state, federal, and local law. And so that means that employees are protected from retaliation when they take legally protected absences under, again, state, federal, or local law. That means they're protected from being assessed any kind of demerit or a deduction from an allotted bank of time, or any kind of disciplinary action, any kind of failure to receive a promotion or loss of pay. And in practice, this means that when an employee takes a legally protected absence, so that could be New York State paid sick leave, that could be New York State paid family leave, it could be the FMLA, or taking FMLA under the federal law. When they take leave under those laws, if they're using that leave legitimately, pursuant to that federal or state or local law, the employer cannot assess any kind of attendance point or attendance occurrence under an attendance policy, such that an employee would be racking up points that would cause them to maybe, fail to receive a promotion, or it might result in a loss of pay or something along those lines. So a better way of explaining this might be to think about it in terms of an actual attendance policy. So for example, say you have an attendance policy that says, regardless of the reason that you are absent, you are assessed a point for every absence. So that would be a no-fault attendance policy. It means, regardless of the reason, you are assessed a point for being absent on a particular day, whether or not you have leave available, regardless of the reason. That under this law would be contrary to the amendment. So if someone was taking paid sick leave and they were assessed a point for being absent when they took paid sick leave, that would be contrary to this new amendment, and you would not be able to do that. So I think the easiest way to get at this law is to carve out the legitimate use of available leave, and to tell employees that any legitimate use of available leave under any kind of statutorily protected leave law will not be considered an occurrence or an absence or whatever it is under your attendance policy. The fines for this are fairly steep if you are in violation of this law, and there's a 2-year statute of limitations. So it's important to think about this and to think about whether or not your attendance policy, for example, needs any kind of revisions. So we have some specific action steps to consider. First and foremost, understand what absences and leaves are legally protected. And I listed off a few: paid sick leave, paid family leave, FMLA, and then consider whether you need to revise your attendance and leave policies. No fault policies should be specifically, again, revised to exclude legally protected absences so that no one is being penalized for taking leave that's protected under the law. It's also probably a good idea to add some non-retaliation language. Employers are not subject to or will not be subjected to retaliation, for exercising their use of legally protected leave. And then also you should ensure that no other employment decisions are improperly consider use of legally protected leave, so that, employees' use of their paid sick leave, for example, doesn't affect their pay increase or their ability to be promoted, for example. So a relatively small amendment, but with potentially wide-reaching implications. Definitely take a look at your attendance policy and see if you may need to make a revision to reflect this change in the law.
Okay, so staying on the topic of leave for another slide, there were some minor changes to New York State paid family leave. As of January 1 of this year, paid family leave is extended to cover siblings with a serious health condition. So paid family leave, just generally speaking, provides 12 weeks of leave to bond with a new child, care for a family member with a serious health condition, or assist a spouse, domestic partner, child, or parent in active military service. And there was a list of family members that is included under paid family leave. Just be aware now that siblings are also included. In addition to including siblings, biological, adopted, step, and half siblings all fit the bill here. There were also some minor changes to the benefit rate and to the employee contribution rate. So the employee contribution rate actually went down a little bit, and the maximum weekly benefit, which is tied to the state's average weekly wage, went up a little bit. So on that end, make sure that you're coordinating with your payroll providers to implement the new rate. And generally speaking, with the addition of sibling, with the amount of benefits changing, with the employee contribution rate changing, make sure that your communications with employees are up to date to reflect the most current amounts, right? So the weekly benefit has always been 67% of the average weekly wage. That 67% has not changed between 2022 and 2023. But the state's average weekly wage changed, and so we have an increase in the maximum weekly benefit. So if your prior communications reflect the 2022 dollar amount, make sure that you're updating that communication for employees going forward to address the 2023 benefit amount.
All right, our next topic is going to be breastfeeding accommodations. There was actually a change on both the state and the federal level in this case. So on the state level, there was an amendment to the already existing breastfeeding accommodations law that's on the books. And that becomes effective June 7th of this year. And then on the federal level, the Pump for Nursing Mothers Act was passed and becomes effective at the end of this month, April 28th. I'll just quickly mention the change on the federal level because the one on the state level is a little more prescriptive. On the federal level, coverage for the ability for somebody to have time to pump after they have a child, that ability has been extended to all employees, not just non-exempt workers. So it's much more far-reaching than it used to be. Of course, in New York State, we have this law on the books, so this matters a little less for New York State, but still a good idea to be aware of the fact that there was a change on the federal level, and that the federal act also says that time must be paid if an employee is not completely relieved from duty, which would also apply at the state level as well. So more specifically, more importantly, the change on the state level was an amendment to the current labor law that says that employees have to be allowed to express breast milk when they, employers are required to give employees the ability to express breast milk. And that must occur at least every 3 hours under state guidance, and it has to be a break of 20 minutes at a time at least. Now, the change to the law says instead of just a reasonable break time, it says employees must be permitted to pump each time they have need. So not a huge change necessarily there, but just be aware of the fact that an employer can't be overly prescriptive about how often someone takes time to express breast milk. If they need to perhaps more often than every 3 hours, that may now be acceptable under the law. So be aware that it's now each time an employee has need, and there are no exceptions to the requirement to allow employees to pump. In addition to that, an employer has to provide a room for employees to pump. Again, this was already on the books, but there are just a few more requirements now that were not previously in the statute itself that you should be aware of. And finally, now there is a requirement to provide a state-created written policy on breastfeeding accommodations to your employees. As far as I know, that written policy has not yet been published by the state, but keep an eye out for it. So a little bit more detail on the changes to the law. This can be unpaid break time, but again, it has to be each time the employee has a reasonable need to pump, and that's for 3 years following childbirth. The state created policy that I mentioned has to be distributed to employees when they're hired every year, and then following the birth of a child as well. And again, watch for that from the state. And then importantly, an employer is now required to respond for a request for a room to pump in no more than 5 days from the request. So when an employee makes a request for a room to pump in, the employer has to be able to respond within 5 days. And the requirements for that room are on this slide. So previously, the Department of Labor in this state encouraged but didn't require a few things, and now they're actually in the statute. So the old requirement did say the room should not be a restroom or a toilet stall. That's still in the statute. And it also has to be a room that's in close proximity to the work area, well lit, shielded from view, free from intrusion, preferably with a lock, but that's under the guidance. It's not necessarily in the statute. The room has to have a chair, a working surface, and nearby access to clean running water and electricity if the workplace has electricity, as well as an electrical outlet. The room has to be available when it's needed and not used for any other purpose when in use by the nursing employee. And an employer has to provide notice to their workforce when such a room has been designated. And then finally, if the workplace has refrigeration, that has to be made available to the employee for use in storing pumped breast milk. Now, if any of these requirements for the room specifically would pose an undue hardship, the employer still has to make reasonable efforts to provide a room that's not a bathroom for the nursing employee. But again, there's no exception for actually allowing a nursing employee to take a break to pump. It's just that there's somewhat of a caveat for the requirement to provide a room. Again, that if it's an undue hardship, then you still have to make reasonable efforts to get to that point. But again, there is a little bit of a caveat there. So you probably already have, or many of you may have already had experience with this law if you have an employee that needed to pump breast milk during the work day. But it's a good idea to make sure that if you haven't designated a room already, or you haven't needed to take note of whether or not you could down the line. So you may not have an employee that has need of it now, but could you comply if, say, tomorrow somebody came to you and said, I need a room to pump breast milk? So I think it's a good idea to think about this ahead of time so that you're not scrambling trying to accommodate an employee that asks down the line.
Okay, I'll talk a little bit about some changes to discrimination and retaliation laws in New York State. So there were some amendments to the New York State Human Rights Law that were effective at the end of 2022. The law was amended to add citizenship or immigration status as a protected category under the New York State Human Rights Law. And the 2022 amendments also included expanding unlawful retaliation to cover disclosing an employee's personnel files because the employee has engaged in protected activity, unless the disclosure was made in the course of a proceeding. So a little bit more information on this. Prior to the change, the Division of Human Rights, who enforces the New York State Human Rights Law, their position was that national origin as a protected class was used to protect discrimination against new Americans or those who were discriminated against because they did not have American citizenship. So it was already a considered protected, but just in a different way. Now the law has added this clarifying status. Now, it was already a protected category in New York City. In case you haven't noticed, New York State often follows New York City. They tend to be the first ones to roll things out, and then the state follows, such is the case here. Now, the purpose of disclosing an employee's personnel files, why that was included as a form of potential retaliation, was to prohibit the release of personal records to discount victims of workplace discrimination, right? The state doesn't want employers going to the media or other public avenues about an employee's past misconduct or performance problems in response to that employee lodging a complaint about discrimination or harassment in the workplace. Now, there is a caveat to this. It does allow the release of personnel records when the employer needs to do so in responding to a complaint, whether that be in a civil action, a criminal action, or in some other type of judicial or administrative proceeding. I'll also do a little quick slide here on New York State COVID leaves. Vaccination leave was extended to be in effect until the end of this year. So just as a refresher, all public and private employers have to provide up to 4 hours of paid leave per injection to receive a COVID-19 vaccine. This includes boosters. I know that I hear, I'm still hearing radio commercials about getting a booster. So just a reminder that this law is still in effect. This type of leave cannot be charged against any other type of leave to which an employee is entitled. So you couldn't make an employee use their paid sick leave, for example, to go and get a COVID-19 vaccine, and they should be paid at their regular rate of pay. And of course, the law prohibits discrimination or retaliation. Another note that COVID-19 quarantine leave is still in effect. I know this is really a blast from the past, but it's still out there. It's still in effect. If you have any questions about the scope of COVID-19 quarantine leave, there's a very helpful FAQ posted on the New York State Paid Family Leave website. But just as a general reminder right now for private employers, for many employers, this involves 5 days of job protected leave, in many cases paid, depending on the size of the employer. And this can be used up to 3 times. Again, check that New York State Paid Family Leave FAQ website if you need a refresher on quarantine leave as well.
I know a lot of employers are really surprised to hear that that's still in effect. Given the fact that cases are so low at this point, it may not have been something you've had to deal with recently. But just be aware, like Chloe said, that it is still on the books, it is still out there, and employees are still entitled to it if they happen to have COVID and are subject to a mandatory or precautionary order of isolation or quarantine.
And also, still on the topic of COVID-19 laws that are still lingering, that are still in effect, we have the New York State HERO Act, or the New York State Health and Essential Rights Act. So this law was in response to COVID, and it mandated certain workplace health and safety measures. The first of which is that employers had to create an airborne infectious disease plan, and that plan had to be posted in the workplace, provided to employees, included in the handbook. And when there is a illness, a disease that's designated as an airborne infectious disease under the HERO Act, that infectious disease plan needs to go into place. It has to be implemented. Right now, there is no designated airborne infectious disease. COVID was designated back in, sometime in 2021, and now as of March 2022 is no longer designated. So there hasn't been quite a bit of time where there hasn't been a designated airborne infectious disease. That does not change your requirement as an employer to have this prevention plan in place and to provide it to employees. Again, you just don't have to go through the steps of implementing the plan when there's not a disease that's being designated. In addition to the plan, the HERO Act also requires employers with at least 10 employees to create a workplace safety committee if an employee requests it. And you have to recognize that committee within 5 business days, or you can face penalties of $50 a day. So to the extent you have employees that are requesting to form a workplace safety committee and you have at least 10 employees, make sure that you're recognizing that committee and putting it together to avoid those penalties.
All right, we've got a couple more updates for you in the last few minutes of our presentation. The first one is on a really recent decision from the National Labor Relations Board. Now, for those of you who don't know, the NLRB covers unionized and non-unionized employees who do not hold supervisory roles. And just a quick refresher, supervisors under the NLRB are employees who exercise authority over other workers, including what the NLRB terms independent judgment. So supervisors that can hire, transfer, suspend, lay off, promote individuals, for example. If you have any questions about whether or not your employees might be, or your supervisors, for example, might be subject to this law, I would encourage you to reach out to your attorney of choice to confirm that, because it can be a bit of a tricky analysis in some cases. But just generally speaking, the NLRB does cover both unionized and non-unionized employees. Just because your workforce isn't unionized doesn't mean that this slide does not apply to you. So this case came down just a few weeks ago, and it involved a Michigan hospital that furloughed unionized employees and offered them confidential release agreements in exchange for a severance package. So not an uncommon occurrence. And that severance agreement prohibited employees from disclosing the severance agreement to anyone else other than a spouse or a professional advisor. And it prohibited the employees from making statements to other employees or to the general public, which could disparage or harm the hospital. Again, not uncommon provisions, confidentiality and non-disparagement. Now, the NLRB considered this agreement and held that these confidentiality and non-disparagement terms in the severance agreement could be restrictive on the exercise of these employees' NLRA, that's the National Labor Relations Act, Section 7 rights. And those are employees' rights to engage in protected concerted activity. So things like discussing terms and conditions of employment, the right to organize, the right to complain about working conditions. So the decision itself held that a confidentiality provision cannot prohibit the discussion of the agreement's terms because that would prevent the employees from discussing a possible labor dispute. And that a non-disparagement clause cannot use language that restricts future efforts by a worker to assist fellow employees, like cooperating with an NLRB investigation. Now, the NLRB General Counsel issued a memorandum, again, a few weeks ago, which is non-binding, but it does interpret this decision. And it indicates that narrowly tailored confidentiality and non-disparagement provisions may be considered lawful. And that disclaimers are also useful tools to include in these types of agreements, but would not necessarily cure overly broad provisions. So what does this mean for you? This means that if you're drafting a separation or severance agreement or settlement agreement, consider whether you need to include confidentiality or non-disparagement provisions. And if you do, they should be narrowly tailored. And you should also consider using a disclaimer that says Section 7 activities are not prohibited. This may be a very common thing that you did previously with your separation agreements if you've entered into those with former employees. So be aware that the language may need to change somewhat based on this decision. And we'll have to see if this decision is upheld by a court, if challenged down the road, which we expect it probably will be. Now, our last update is related to the issue of confidentiality and non-disparagement, and that is because of the recent passage of the Federal Speak Out Act, which became effective December 7th of last year. So this federal act prohibits non-disclosure and non-disparagement clauses in contracts or agreements agreed to before a dispute arises involving sexual assault or sexual harassment. So what does that mean? That means that employers cannot enforce confidentiality and non-disparagement provisions in the context of sexual harassment or sexual assault claims. It's basically intended to ensure that individuals can come forward with these types of allegations, notwithstanding the existence of these limitations in an agreement that they might be subject to. This includes agreements between employers and current, former, or prospective employees, and as well as independent contractors. Employers can still protect trade secrets and proprietary information, but you should be aware of this limitation. Now, interestingly, while the federal act does not cover post-dispute issues, New York state law already generally bans non-disclosure agreements in discrimination cases, except where the person who complained prefers a non-disclosure agreement. And there's a whole process to record the fact that the person who complained wants confidentiality in an agreement, but you have to follow that process or at least follow, the guidelines that the state has put out, or the law that the state has put out, in order to include confidentiality in a separation or a settlement agreement. And those restrictions, those are not new in New York State. The restriction on non-disclosure agreements in relation to discrimination claims went into effect in 2019. So that's been around already. There's just an additional layer now to think about on the federal level. And again, this is in the context of sexual assault or sexual harassment allegations on the federal level. So that is our final update. I'll pass it on to Chloe. We're almost at the top of the hour, and we appreciate everyone signing on with us today.
Yeah, I would just echo what you said, Anna. We appreciate your time today. We hope this information was helpful to you. We know that there are a lot of laws that we covered in a short amount of time. And so to the extent you have questions, our contact information is on that slide. And so thank you, and thank you to the Kenton Chamber for having us again.